Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Jaclyn Phillips, and today's episode is called, Is the Failing Firm Defense Thriving? Assessing when a failing firm can make a deal succeed. Merging parties can argue that a deal that might otherwise raise competitive concerns should go through because the acquired firm is doing poorly economically. In other words, it would fail without being acquired. Traditionally, the proof needed to put on such a defense can be difficult, and the FTC and DOJ generally look upon such a defense skeptically. Today, we'll walk through a recent court decision where the merging parties prevailed against the FTC with a failing firm defense, and assess what that might mean for future transactions where a failing firm defense may be viable. I'm here with my co-host, Anora Wang. Hey, Anora.
Hi, Jaclyn.
Who do we have with us today?
Well, I'm glad to introduce our guest speaker today, Chris Wilson, who is a litigation partner in Antitrust Group at the law firm Paul Weiss, where he advised clients on a full range of antitrust matters. Chris's areas of expertise include merger enforcement, interlocking, directorate rates, joint ventures, compliance programs, and employee no-poach agreements. Prior to his prior practice, Chris was a trial attorney in the Transportation, Energy, and Agriculture section of the U.S. Department of Justice's Antitrust Division. While at the DOJ, Chris received the Antitrust Division's Award of Distinction on 2 separate occasions. Chris, welcome to the program. Chris, with Jaclyn's wonderful table setting, why don't we just go to the basics a little bit more? Could you tell us what is the failing firm defense in the realm of, U.S. antitrust law, right? We're not so much talking about international, but how is it used in litigation or investigation as a defense for merging parties?
Sure thing. So before I launch into it, the views and opinions I'm going to express today are solely my own. They're not the views of my firm, Paul Weiss, or of our clients. But basically, the failing firm defense is a rebuttal to a prima facie case of substantial harm to competition from a proposed transaction. I think most people listening probably know that the government bears the burden of proof to show that a merger substantially harms competition. But once it's done so, then the burden shifts to the defendant to show that market shares or other facts that the government presented kind of give an inaccurate account of whether or how a deal is going to harm competition. So the failing firm defense is kind of like a lesser of two evils, and I'll get to why in a moment. But it's born out of the seminal, I think it's a seminal case of U.S. v. General Dynamics, which dates all the way back to 1974. And in our realm, General Dynamics is probably well known, or better known, I should say, for the idea that defendants could even counter the government's prima facie case with other evidence that shows that the government's case doesn't really tell the full story. But I think General Dynamics is also really important because I think it's the first time we saw kind of a judicial recognition of a failing firm type of defense to a Section 7 claim. So the lesser of two evils things that I was talking about a moment ago is, on the one hand, you have this alleged evil of potential harm to competition from a combination. But on the other hand, you have potentially greater evil, right? Which is, if the firm that's going to be acquired is itself in dire straits, such that it's going to go out of business and simply exit the market without the deal, then the rationale is that it's better to keep the business and these assets in the market, even if it is, through a merger with a competitor. So kind of to make this out, the defendant has to show, I would say, 2 things. First, it's got to show that the resources of the target were so depleted and its prospects were so bleak that it was likely to fail as a business. It was going to exit the market. And then 2, the defendant's also got to show that there was no other prospective buyer for these assets.
Perhaps this is a time for clarification. So you said the resource of target was so depleted. That's the failing term come in, right? Sometimes we heard failing, flailing. Is it sufficient just to flail, not to actually
Yeah,
fail?
we'll get to it in a second. I think the idea is it's got to be failing, not simply not doing so hot. But we'll get to that in a little bit.
Thanks, Chris. And before we dig into that, I made kind of a general statement that the agencies have been skeptical of this defense, but I want to get your take on that. So traditionally, and I guess putting aside the Novant case that we're going to talk about today, how have the agencies and the courts treated failing firm? Has it generally been met with success?
Yeah, so having been at DOJ myself, I would say if it's presented, I'd say there was some initial skepticism because the doctrine is basically saying, yes, government, you're right. This deal is bad for competition. All those facts are correct, but nevertheless, you should lose because the alternative, right, that the assets are going to exit the market, that it's going to go out of business is a worse outcome. So I would say there is some skepticism, some initial skepticism from the government that this is truly the case. Courts, on the other hand, they acknowledge that the doctrine does exist, but they want to know what facts are there that support that this is the case. What is the facts supporting each element? Is this business truly in dire straits, or is it simply kind of just going through a soft spot? Is there really no other buyer for these assets other than the defendant? What all have the defendants done to canvass the marketplace to really make sure that there is no one else out there that's a better buyer that can acquire and save this business?
Yeah, so I think this is something we're not seeing all the time in cases. Are there any more recent examples that can illustrate this defense for our listeners?
Yeah, other than Novant, there's a great case about 6 or 7 years ago called US v. Energy Solutions. So that case concerned the potential combination of two nuclear waste storage companies, Energy Solutions on one hand, and then Waste Control Specialists on the other. And I'm just going to call them WCS because I'm not going to get Waste Control Specialists right every single time. But basically, the government contended that that Energy Solutions and WCS were close competitors and two of only a few competitors for the storage of low-level nuclear waste. And when I say low-level, just so you know, I mean things like radioactive components from hospital equipment and not like spent nuclear fuel rods or something like that. But made that case out at trial, right, that the combination was likely to harm competition. So WCS raised the failing firm defense, and it pointed to, I would say, three things to support that defense. One, it asserted that the amount of low-level waste that was being created by customers as a whole, by the industry as a whole, had declined or had simply not grown, such that WCS was never going to kind of reach the scale and size it needed to actually become a viable, like long-lasting, enduring competitor. And kind of subservient to that, it had pointed to the fact that it had never turned a profit despite being around for several years, and had repeatedly missed its own financial projections. So, the government took in all this evidence. It concluded it was a very close call, but ultimately it ruled that WCS had not carried its burden in proving the defense, mainly pointing to the second element, which was the question of whether there was no other buyer other than Energy Solutions. The court concluded it was a very close call, but it ultimately ruled that WCS didn't carry its burden on the second element, which was whether there was no other buyer other than Energy Solutions. The court concluded that WCS had not marketed itself broadly enough to for it to successfully assert that Energy Solutions was the only buyer for these assets. And so the court rejected the defense on that point, which ended up handing a win to the government.
Got it. And that, brought us back to Anora's question earlier. What do we really need to show failing? It looks like, WCS wasn't doing too hot, and that didn't carry the day here. So moving on to the applications of the failing firm defense in the Novant deal. Tell us about that.
Sure. So in late 2023, Novant Health, which is a regional North Carolina and South Carolina hospital and physician practices system, it proposed to acquire two hospitals in North Carolina. The first is Lake Norman Medical Center, and the second is Davis Psychiatric Hospital, from a hospital system called Community Health Systems. After an investigation, the FTC elected to file suit to block the proposed transaction, asserting that it was going to reduce competition in the lines of service offered by Novant and Lake Norman and Davis, which was mainly inpatient acute care. And just so people know, the FTC here was seeking a preliminary injunction so that its in-house administrative proceeding could play out. So the standard that the court was going to apply here was slightly different from the Energy Solutions case, in that the Novant court had to decide if the FTC was likely to prevail at trial or whether the defendants were likely to rebut the FTC's prima facie case. So it's a slightly different question from the Energy Solutions case.
And just so we're clear, how did it differ from Energy Solutions? How was the court assessing it in that case?
So the Energy Solutions case was a full trial on the merits, whereas the Novant case was a decision on whether to enter a preliminary injunction. And so just the standard of the court, how the court was going to analyze the facts, it's slightly different. I mean, fundamentally, it's essentially the same, but it's just a slightly different procedural posture.
Got it. So how did the failing firm defense come into play?
So basically, the two hospitals to be acquired, Lake Norman and Davis Psychiatric, they had been struggling for some time before the transaction. And Novant viewed the acquisition as an opportunity to resuscitate both facilities. And the defendants raised the failing firm defense as the primary counter to the FTC's prima facie case.
Got it. And clearly the FTC didn't think that was going to win the day, but walk us through the court's decision. What finding led to the court's decision that the parties would likely be successful in rebutting the FTC's prima facie case? Not to kind of skip to the end there, but give it away.
Yeah, no worries. The court concluded that there was clear evidence that the Davis Psychiatric Hospital was going to close if there wasn't a deal. And as to Lake Norman, the Lake Norman Hospital, and I'll quote the court here, it said the future competitive landscape suggested that the hospital would not be able to sustain its current level of competition. And it added that the competitive position was likely to erode to a point where it was likely to close in the foreseeable future, which would have fully eliminated it as a competitor. And, the court, I think, took some pains to point out that the Lake Norman and Davis's kind of competitive vigor was in deep decline. For example, Lake Norman had eliminated several lines of service, and the management for both hospitals had repeatedly declined to make additional investments into the facilities. And so that led up to the conclusion by the court that the closure of both facilities was a grave probability. And for Davis in particular, the court thought without this deal, Davis was going to shut down immediately. And the court had also found, and was also persuaded by the fact that the hospitals had been put up for sale on previous occasions, and on each time there was no bidder.
So how did the court's decision align with the current merger guidelines and prior decisions dealing with failing firm defense? So
I would say the decision is mainly in line with the current merger guidelines and with general dynamics. The most recent version of the merger guidelines essentially restate the general dynamics factors, and I would say that's generally how the court analyzed the deal. But I think there was one interesting point regarding Lake Norman. And for Lake Norman, the court said that stated that the evidence indicated that Lake Norman was going to continue on, but almost in a zombie-like state. And specifically, the court stated that, in the absence of a sale, there was no reason to believe that Community Health will do anything other than continue to operate Lake Norman with very limited investments. And I'll quote again, Community Health will continue to allocate funds toward the required maintenance of the facility, but will not allocate any meaningful growth capital. So I think there was an argument that expands the application of the failing firm defense a bit, because what the court arguably was saying there is not really the standard under General Dynamics, which says, right, that closure has to be a grave probability. But what the court seemed to be saying with these statements is that the defense is viable, is applicable, if the company can continue on as a going concern, but only on life support, so to speak.
Yeah. Just not a so serious comment here. The way listening through you comparing Novant and General Dynamics, I cannot stop but thinking maybe the essence of the advocacy is really about making great metaphors, right? Like, if you're just a energy, waste company that's not doing so hot, you're not deserving the failing firm defense. But if you are sort of on the lifeline support here, you're in the ER room, you're almost like a zombie-like state, you're almost having to go to the ER, and then there's only one doctor in town, you probably get a pass. So that's not a joking aside. So what is happening next? Is the decision in Novant being appealed now? What's going to happen next?
The FTC lost, and so they filed a notice of appeal of the decision. Although, unfortunately, we're not going to get to hear the FTC's arguments about why the decision was incorrect. And this is because the Fourth Circuit agreed to take up the matter on appeal, but it also stopped the deal from going forward pending an appellate decision, which was going to have the effect of further delaying closing. And so, unfortunately, the parties just elected to abandon the transaction. So we're not going to really hear the Fourth Circuit's view on the Novant matter, unfortunately.
So other than my not so serious metaphor about not so serious comment about metaphor, is there anything that merging parties should take away from the observation of the Novant deal and the decision moving forward?
So number one, the Novant decision showed that the failing firm defense can actually prevail. And it's not necessarily a moonshot type of defense that has really only very, very narrow application. I would say the decision is also a really nice examination of the kinds of evidence and maybe the presentation of that evidence and how that's going to be persuasive when it comes to successfully asserting the failing firm defense. But for example, I personally thought that the fact that Lake Norman was closing lines of business, maybe that was a more compelling and visceral example of decline than simply saying, well, my company isn't profitable or we missed our financial projections. And I think it's also important to kind of have a story, right? To paint a picture for the fact finder. And I think you put your finger on it, Anora, when you said, a judge may find it easier to envision a physical thing or a place kind of closing its doors and shutting down than this kind of inchoate thing like a corporation going out of business. So, I think from that, what we can also take is that the failing firm defense, I think, is more likely to be successful if you have fleshed it out as early as you possibly can, right? Because what's not going to work is kind of throwing it in at the end and saying, oh, by the way, also, we want to assert this failing firm defense, right? You want to build everything up to it. What are all the instances that show that this business is declining and is going to fail? What are all the things that the business did to try to survive, to try to turn things around? And what are all the efforts it made to try to find another buyer, to try to find some alternative, right? And I don't think you can gather all that together and develop that if you're right, on the courthouse steps. It almost presupposes a lot of things have happened before the deal was even signed. And so you have to really think about all that stuff and get it all together
Right.
in advance.
Right. Yeah. Just circling back to the initial comment that we had in the program, this is not something that the courts or the agencies have looked upon favorably traditionally, right? And so does it merging parties really have to make a choice at the beginning, right? You cannot hold on to it as if it's a card you have, at the very end of the game, by the way, we're failing. So cannot really do that. Wonderful discussion. I'm going to turn it to Jaclyn to wrap this up a little bit, maybe turn it to a more personal segment.
Yeah, thanks, Chris. All very interesting, and we'll link that decision and information about it with the episode so listeners can learn more. But before we let you go, why don't you tell us something about yourself we may not know if we've only worked with you?
Oh, gosh. Okay. Well, anyone who knows me outside the professional context knows that I love cars, I love racing, I love Formula One. I've been to 5 different countries, I think, to watch Formula One races, and for people who don't know, it's a form of car racing. It's just cars going in a circle, but the 12-year-old boy in me just loves it still, even though I'm old.
How many countries are Formula One competing at?
19 different.
19. Oh, you have a lot.
I got a bunch of continents. Yeah, I got to get to Asia. I got to get to Australia. I got to get to South. I got a lot of places to go.
This Curious Hat's question is going to be, so what's your team? Who's your driver?
Gosh. So I love Mercedes-Benz. Lewis Hamilton, surprise, is my favorite driver. I've been watching him since I was a long time now. You can't see it. I have all this Mercedes merchandise, and guess what? I don't even know Mercedes.
What are you going to do next year?
I don't know. Probably my dad asked me the same thing.
Lewis was going to Ferrari for
red doesn't work for my complexion, so I think I'll just have to stick with Mercedes and just have divided loyalties, I guess.
It's good to have a little competition among the teams.
My dad thinks now we need to go to Italy, and I'm like, sure, man. Okay, we'll figure it out.
Yeah, that's tough.
So.
All right. Well, I hope you enjoy the second half of the season. It's August 2024 right now. And thanks for joining us on our Curious Amalgam.
Absolutely. Thank you for having me.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.